Hey, today we will try to imagine walking into a federal courtroom, like in the sense of hands sweating, heart racing, and when you're convinced you have like a real solid case of workplace discrimination or whatever, and you've been waiting for this day for years, hoping for a justice. But here is the hard truth: the odds are stacked against the plaintiffs in the federal court. And studies shows that employees bringing job discrimination cases to a trial in the federal court win only in about 15% of the case, and compared to a 51 win rate for other civil plaintiffs, like let's say in a circuit court. And in fact, so less than 5% of a discrimination plaintiffs ever achieve any relief through litigation. Those are just the sobering numbers. So why are these trials are so difficult to win, even when you feel your case is strong? And more importantly, what can you do to beat those odds? In today's video, we are going to expose the realities of federal trials, especially in employment cases, and arm you with the knowledge you need, with insider strategies to maximize your chances of victory. And by the end, you will understand the process from start to finish, why it's so challenging, and how exceptional preparation and tactics can make the difference. So if you're just a wronged employee or just anyone headed to a court, so ready to fight for justice, and keep watching. This is just the knowledge that most people and even most attorneys don't know about winning in a federal court. Number one question, so why plaintiffs face long odds? Federal civil trials are just plainly are different so that than what you see on a TV. That can seem almost rigged against employees, so suing their employers. You may say why. So first, federal judges have been just interpreting employment laws very narrowly in the recent years. And many cases get thrown out just before they ever reach a jury. So either dismissed early or ended by a summary judgment, that pretrial motion that can shut your case down. And by the time you actually get in front of a jury, so you're already just one of the lucky just few who survive those hurdles. And even then, winning is hard. And the judges often apply legal doctrines that favor employers, sometimes in jaw-dropping ways. For example, in what one scholar called an alternative reality of discrimination law, so one federal court said a supervisor, just a grouping for among priests, once or twice wasn't serious enough to count as illegal harassment. And the managers remarked that all breaks are lazy, will dismissed as a mere just a stray remark and not evidence of racism. It may be shocking, right? But yet, so such rulings show so how high bar so can be for plaintiffs. And the courts have even just created things like the honest belief rule, which lets an employer so win if they can show they honestly, even if incorrectly, believe their reason for firing you. And some doctrines that lets judges disregard the clear signs of discrimination. Unfortunately, it's a reality of our times. And on top of that, the burden of proof is on you as a plaintiff, so just to prove your case. And often with only just a circumstantial evidence, because most of the cases, they don't have smoking gun evidence. So you may head on with he said, she said, hearsay case. So and employers rarely just leave a smoking gun email just admitting that I fired her so because of her race. They will not be even just producing during the discovery yet unless you push them very hard, and if they have it. But instead, so you must convince the juries that the employer's supposed reason for firing you was just an excuse, pretext, so like hiding the real like illegal motive. And that's a tall order. And remember, so in federal courts, the verdict must be unanimous. You typically need just all 6 to 8 jurors on your side. Just one holdout juror can cause a mistrial or hang the jury, so forcing you to potentially just redo the whole trial. And all these factors, like skeptical judges, tough legal standards, those high bar pleadings, unanimous juries, everything help explain so why it's so difficult for a plaintiff to win, even when you generally just suffer discrimination or harassment. And and difficult doesn't mean impossible. So it just means you need to approach the trial differently. So armed with a strategy and an understanding of the system's quirks. And next, after this essential step, we will walk step by step through the trial process. So from before it even just begins to the final verdict. And we will try to highlight how a determined plaintiff can turn the tables, like David versus Goliath. And every single case starts from a complaint to a courtroom. That's a road to a trial. And every trial journey starts long before the jury is sworn in. So in a typical Title VII employment case, for example, a sexual harassment or retaliation lawsuit, you would begin by filing a charge with EOC, Equal Employment Opportunity Commission, and then a lawsuit in the federal court. And a month or years of a trial, that's just those preparation, follow. And your lawyer or you, if you are represented yourself, so engaged in a very long process called discovery. So like gathering evidence, emails, HR records, witness depositions, and everything that works, everything that may just come up useful and circumstantial. I mean, so the stage is critical, as you're aware, because the evidence you uncover will make or break your case and determine if you even get to a trial, as only less than 5% of all the cases ever reach a trial. So before a trial, the defense will almost certainly just file a motion for summary judgment, so like arguing to the judge that an unreasonable jury could find in your favor. So your job is to find as many as possible contested evidence. So like you should find every single contradiction, lie, exaggeration, everything that may create doubt and that may help you to overcome the summary judgment motion. This is a major checkpoint, so in the federal cases. And unfortunately, for plaintiffs, judges grant summary judgment in employment cases at just an alarming rate, as many harassment, discrimination, and retaliation claims get dismissed on paper, so like never seeing a jury. And to survive this, you must marshal just enough evidence to show there is a genuine dispute of material fact, which is very hard. And in plain English, you must convince the judge that a real jury could believe your side of the story. And for example, if you allege you were fired in retaliation for complaining about harassment, and you would better have some proof of a timing or a comment, just that's just a link between your complaint and the firing. So let's say emails or a testimony showing your boss started just nitpicking your work just right after you reported him. And if you clear the summary judgment hurdle, like it's a big congratulation. So you won the first battle. And many strong cases fall short before just here, and because they didn't gather the right evidence or frame it incorrectly under the legal standards and those high pleading standards. So now it's time to actually go to trial. Imagine, which in a federal court rises just faster and moves quicker than you might expect. As your trial date approaches, so there is a jury or a final preparation, and both sides submit a pretrial order, like listing witnesses and exhibits, so like filing motion in limine and request to allow or keep out just a certain evidence, and exchange proposed just jury instructions. And every federal judge also has their own local rules or standing orders about the pretrial preparation. And if you ignore at least one of those, at your peril, so judges can and will sanction or even dismiss your case if you just float their procedures. For instance, some judges require you to submit exhibits just in those big binders or a jury question, so like weeks in advance. And if you're representing yourself, you would not be able, to do it correctly in order. And and read the judge standing orders so carefully, like usually on the court's website, and just follow them like to the letter. So and even one attorney advises. So, like knowing the federal rules, the local courtrooms, and your judge's individual rules in that order is a very beneficial and essential. I mean, at the pretrial preparation, as for everything from filing briefs to how to address a court is a kind of framing. So you're just framing your case. You're showing that you're ready for a trial, that you're just giving a reason. So why this case should be there. And the federal judges do not just appreciate surprises or sloppiness, even if you are a pro se plaintiff, so not represented. As the saying goes, so like failing to prepare is preparing to fail. And nowhere is that just truer than in federal court. And finally, so the big day arrives, trial. So you keep into that courtroom, and you've only seen in the movies or maybe in the preliminary hearing, and immediately, so you notice the formality and the precision of environment. So you see the U.S. Marshal staff, the entrance, so those security guys, and everyone just stands. So when the judge enters, and everything looks creepy. So you're under a big impression because you're not used to those accommodations, and you see that many people are watching, and there are some news just covering those topics, and you address the judge as your honor at all times. And and one quick tip, so like every time you arrive there, so always stand when speaking, can never just interrupt the judge, because many cases are just unintentionally just getting collapsed at that stage, because that respect goes a long way. And if you're the plaintiff, you sit in the counsel's table, like closest to the jury box, because they should see you. They should see like your reasons and your personality, like how you react. And since you carry the burden of proof, and in fact, even the small details are just regimented, and like, did you know the plaintiff's trial exhibit? So everything must have yellow tags, and the defendant's exhibit so have like a blue tags in the federal court, and those are things that are just used to simplify, I mean, for a judge and a jury, but it's very hard to organize everything like and present in a very short time frame. And many plaintiffs are suffering with the structuring process, which is how things are. And it can be intimidating. But remember, so the structure can also work in your favor. And if you know how to operate with it better than other side, then you may win. You may win by on the paper, and this is a very psychological will. So the defendant will be scared. So they may approach you with a settlement offer if they will see that you're not getting rattled, you're very organized. And even if your case is not as strong as you may hope, but picking a battlefield is a thing that is done. So you're already in battle. So like trials is a war. And unlike dramatic state courts trials that show a lengthy, like a word dial, like a questions and questioning to the jurors, in a federal court, so this phase is often just a quick and limited. And many federal judges conduct the voir dire themselves, so asking a standard set of questions, and it gives their lawyers just a time and little time, if any, just to pose their own questions. And don't expect just to spend days grilling jurors. So you might get like 15, 30 minutes total, or simply have to submit the questions for the judge to ask. And this means that you must make a snap judgment on just who might be biased. So your goal is to just weed out the jurors who cannot just be fair to a plaintiff employee. And for instance, if a potential juror says they strongly believe most discrimination cases are just are created by people just playing a victim, so you or the judge should excuse them for a bias. And each side typically has a few, just maybe temporary strikes to remove jurors without giving a reason. But these are very limited. So use them wisely to remove the HR manager who always side with the company. And one insider trick tip. So if you are just new to a particular federal court, try to observe jury selection in that court just beforehand, just to see the judge's style. And the different judges have different approaches. So some might just allow more questioning. Just others move just extremely fast. And knowing this in advance helps you prepare your strategy. But also you should be aware that federal judges in civil cases are usually smaller, like often 6 to 8 jurors, and must return anonymous just a verdict for you to win. So you're aiming for a small group of people who will all sympathize with your case. And even if one juror, like who isn't convinced, can derail your victory. And you should always keep in mind that you are not just looking for a majority. You need every single juror on your side in the end. And when a jury selection is over, you will have a panel of citizens just sitting in a box, just eyeing you and the defense. This is your audience for the trial story, like in a sense how it's going to be appearing in the news. And the trial truly begins the moment those jurors first see you and your attorney, and they will form impressions quickly. So make sure you and your team are professional and just courteous from the goal to dress neatly, like be organized and treat everyone with respect. And the jurors notice things like an attorney being rude or disorganized, and it can just assure them. And now it's a show time. So like opening statements right after you selected a jury. And in an opening statements, you may shape the story. The weak case may appear strong, and the strong case may become weak. And in the federal court, so the judges will invite the plaintiff's side to speak first, since you carry the burden of proof. And the opening statement is your first chance to grab the jury's attention and frame the narrative. And this is not just a place for a dry legal jargon or rattling just over just every fact. It's about your story, a human story of betrayal, injustice, and just ultimately a plea of a fair treatment. And in an employment case, for example, your attorney might begin, ladies and gentlemen of the jury, imagine going to work every day dreaming what your boss might do or say. And that was Alice's life. Alice worked at XYZ Corp for 5 years. She loved her job until a new supervisor, let's say John, and he began just a campaign of harassment against her. Today you will hear now just Alice stood up for herself by just reporting the harassment and how the company she served retaliated by firing her. And this case is about accountability, like holding XYZ Corporation accountable for breaking a law and Alice trust. And in those first minutes, you want to lay out a clear, compelling narrative arc. So why you are, what's happening to you, and why it was wrong. And importantly, so promise only what you can prove, as the federal judges will sustain objections if an opening argument just goes too far from arguing or referencing to audience that won't be presented. And a good plaintiff's opening in a discrimination case might outline the key evidence to come. You will see emails from before and after Alice's complaint. You will hear testimony from a coworker who witnessed John's behavior, and you will see the company's own investigation or a lack thereof. And that signals to the jury, like, pay attention, so we have receipts. And the defense will then give their opening, So like prepare yourself. It can be frustrating to listen to. The defense lawyer's job is to just to provide an alternate testimony, and often that paints you as either just mistaken or even dishonest. So they will try to muddy the water, and just continuing our just example of that XYZ corporation. That defense attorney might calmly say, "This case is about performance, not retaliation." You will hear that Alice had been warned multiple times about her job performance, and the supervisor John treated her like any other employee, and the company fired her only after she failed to improve. Like the talk of harassment came only after she was facing termination as a way to excuse her poor work. Ouch. So it's basically calling you a liar, just without using the word, and do not just let anger just get the best of you here. So like juries expect some conflict in the stories, especially in the he's had, she's had cases. So your job is to maintain credibility. So let your evidence do the just demolishing of the defense story. So when the time comes, and the semi-plaintiff's lawyer will have a supply address these expected tactics and attacks in their opening. So, for instance, mentioning that Alice did like get one bad review. So right after she filed her harassment complaint, like to show a jury a suspicious timing pattern, the defense will not reduce the opening statement just after listening here. So it's not like enough time for them to adjust something like significant. And by preempting the defense, so you don't like you're scrambling. So when their version come out, and you're just going ahead, you're going on their pants. So you're just damaging, you're poking the holes in their account. And presenting your case, your evidence, your witnesses is a part. So where you're setting a tone. So where you're just heading towards a win or lose. So like after opening, the plaintiff side presents its case in chief. So this is where all the preparation pays off. Like every piece of evidence, every witness should support your narrative. And in the federal trial, efficiency is a key. So remember, many federal judges aim to complete even the complex trials in 2-3 days. And that means no wasted time on relevant details or some cumulative testimony. And one experienced federal trial lawyer put it in a way, so imagine your trial is a Hollywood movie, like months or years of footage, like everything boiled down in the most compelling 1.5 hour that keeps the jury engaged. So focus on the strongest points and evidence. So like don't try to tell every little tangent. And so let me illustrate with our just hypothetical like Alice with XYZ Corporation trial. Let's say that Alice takes a stand as the first witness, like a common in employment cases, since she can describe what happened to her. And her attorney conducts a direct examination, which means asking open-ended questions. So Alice can tell her story, like what your experience working under John, how did he report it when you reported the harassment to HR, and so on. Though Alice's testimony, so the jury hears this about the offensive remarks that John made and how he cornered her in the break room one day, and she might describe feeling scared or humiliated, and how she complained suddenly her performance reviews and the previous teller, and everything turned negative. And as Alice speaks, her attorney may introduce documents as a form of proof, but everything will depend on how everything presented, and you may expect that defense will later try to cross-examine. They will try to minimize or distort the facts, the timeline, and they might object that something is irrelevant or hearsay or asked and answered, and this is normal. So your attorney should respond calmly with why it's allowed. So, Your Honor, this goes to the supervisor's motive, which is very relevant. And if you are representing yourself, so like no as a common objections and the rules, nothing kills your credibility. So like not knowing how to handle an objection. And for instance, if the defense objects that your line of questioning is a hearsay, so maybe you asked Alice about what a coworker told her, and you should be ready to either rephrase the question or explain so why it's an exception to hearsay. And preparation here is crucial. You should always script out like your direct exam and anticipate like the objections to so you have responses ready. You should anticipate every dirty question that they may ask you that may collapse your case. You should be consistent, especially on a cross-examination. And remember, so to only ask questions the answer, just to form your prep. And the federal court is not just a place for surprises. So you should try to aim to minimize surprises as best as you can. And during the defense case, so you get a cross-examiner, just they are witnesses too. And this is your opportunity to find the cracks in their company story. And for instance, when John, the accused harasser, testifies, he will probably deny any wrongdoing and say he treated Alice like everyone. So, or that he was just legitimately disciplining her for a poor work. And on the cross, your attorney can confront John with evidence like, Mr. Doe, isn't it true you never issued a single written warning to Alice about her performance until 1 week after she filed her harassment complaint? And that is a powerful sequence. If he admits it, it shows retaliation. It shows the timing. And if he squirms or lies, and you can impeach his with documents, so it undermines his credibility. And similarly, a cross-examination of the HR rep about how seriously or not they investigated Alice's complaint, and maybe they never investigated or interviewed the key witnesses or conveniently lost their files, so things that suggested the cover-up or indifference. An effective cross-examination can turn the tables by showing the defense witnesses are just the ones that are not credible or that their story doesn't end up. And one insider tactic always notes that if a defense witness says something different from what they say in a deposition, like a pretrial sworn testimony, you can impeach them by quoting their deposition transcript. For example, you testify today that everyone was happy with Alice's work prior to her complaint. Do you recall giving a deposition in this case last year? And you should always have the script ready. And you may ask something like, didn't you actually say I wasn't really aware of Alice's work quality, so when I asked about your performance? And catching a witness in an inconsistency like that can seriously damage the defense case, and it shows the jury that maybe the company's story can't be trusted. And once the defense rests, sometimes the plaintiff has a chance to offer a brief rebuttal with evidence, just to counter something new that came up. So you should always try to tell the judge and the jury that those witnesses are not credible by poking holes in their account. But let's assume that all evidence is now in. So the judge will have given the jury instructions on a law, so more than in the moment. And then we proceeded to the final part of a trial, like closing arguments. And when you're trying to closing your arguments, like sealing the deal, you should always prepare the right arguments, like the most crucial arguments. So each side, so like last short to speak directly to the jury about your case. They should be like very concise. And by now, the jurors have heard all the evidence. They will likely just form impressions, but may not just have made up their minds completely. And as a plaintiff, you get to go first in a closing, and sometimes it's a short rebuttal, so after the defense. So since you have the burden, and this is where you tie everything together, your narrative and evidence, and woven with the legal standards, and the judge has instructed the jury to apply. And in the federal employment cases, that what always happens is that the judge will instruct the jury on the things like definition of harassment or retaliation, and the preponderance of evidence is standard, and you win if it's just more likely than not that the employer did wrong. And possibly the elements of a McDonnell-Douglas test though that framework is often for a judge analysis, so not explicitly given to jurors. But the key is simply to simplify the law and show how the facts meeting. And for example, so you might tell the jury, as a judge just instructed you that to prove a retaliation, Alice must show her complaint of harassment was a motivating factor in her firing. And let's look at the timeline. So 1 week after she reported John, she got her first bad review in 5 years. And a month later, she was fired with no other cause. And the timing alone is a powerful evidence of a motivating factor, but there is more. So remember the email from the HR. So we need to deal with Alice's attitude, and that was written 2 days after her complaint. And they weren't just concerned about performance; they were annoyed she spoke up. And that's retaliation, plain and simple. You systematically just go through the points of your case, harassment occurred, so sides testimony, and maybe just remind them of any corroborating witnesses. And the company failed to protect Alice, so no serious investigation or a discipline of John. And then they punished her for asserting her rights, and all evidence showing retaliation. And then you're trying to emotionally appeal, which is very important. But balancing things up is what makes your case like readable. So you are trying to simplify the analysis for jurors and a judge, and by the time you stand up to speak to a jury, so the truly critical work should have been done. So what does it entail, and you're trying to pull back the curtain with meticulous preparation of evidence. As a federal trials, so you often just amass essential exhibits, so they send copies of exhibits with the other side just beforehand. As both sides and the judge, so we'll have a binder of a digital file, and when you're facing those critical moments at the middle of a trial, so you can't just swift left or right just from the evidence binder, from a list of exhibits that you already presented to the court, and it's like a plan. So like winning strategies recap is always works on the paper. So like when you're already prepared all the binders, when you're already going through what you was expecting, and the court knows what is going to be presented. So like you covered a lot of ground. So let's just distill some of the key strategies that can just give a plaintiff an edge in the federal court. And this is the nuggets, so even many attorneys might not know unless they have been in the trenches. It's basically just what we've all just talked about briefly, but everything in specific. So like mastering the rules and the judge preferences is it's things that just the winning side always do. Like federal courts is unforgiving on procedure, like know your judge, standing orders inside out. It's a very important trick. Like for example, some judges require pre-marking exhibits like specific citation formats, or even using yellow tickets for a plaintiff's exhibits and a blue for defense. And it sounds nitpicky, but not following this can just annoy the judge, or worse. Also, so be aware of things like strict timeline and those limits for openings and closings, or the judge typical schedule. So like some run trials from 9 to 2 p.m. with a no lunch. And the more you appear as a side who has it together, so the more credibility you gain. And when you're crafting a clear theme, so like your case should have a memorable theme, or a theory that jurors can easily walk just about in the deliberations. And sometimes like no one is above the law. Like retaliation is a violation of trust, or a promise is broken, and a company that preaches respect but practice discrimination is not just allowed to just go away with something like this. And when you use a specific term, so in a voir dire, so like opening and closing, and and all the repetition, like without overdoing, helps it stick. You should stick all the evidence. You should stick all the sticky notes and facts to them, like to create as much depth as possible. And a clear theme also helps you decide what evidence to emphasize. And if your theme is employer dishonesty, so you will highlight every instance they lied or changed their story. And by streamlining your case, you can't just say this is enough. So less is more in a trial. You don't put down on a 10 witnesses if five can cover it, and you're not introducing 50 documents when the 10 best ones will do. And it's about like focusing the jury on the strongest, like most direct evidence of wrongdoing. And this not only keeps the jury engaged, but it also leaves less opportunity for defense to confuse or distract with some issues. And every extra hour of a trial is an hour where something could go wrong. And the judge in a federal case so once advised a lawyer to present their case like a highlight, like a reel, so like not a slow documentary. It should be very vivid, very expressive, especially at the trial stage, and it should take that to the heart. And at every single stage, you should maintain professionalism and credibility. And in a federal court, especially, so being overly dramatic or hostile will backfire. Jurors and judges notice how you conduct yourself if you represent yourself. So, like, be exceedingly polite, refer to the judge as your honor, and the opposing counsel as Mr., Mrs. So stand when speaking and never argue with the judge ruling. So make your record, but respectfully move on, and demonstrating like a calm confidence and integrity, and that will make the jury trust you more than if you seem combative or erratic. And one practical tip is that if the defense makes an objection that is sustained, so meaning that the judge agrees and it tells you to move on, so do not roll your eyes or have. So just say yes, yes, Your Honor, and continue. And the jury will see you as a reasonable party. And remember, so you are not playing the long game of credibility. So you should always like be consistent and be very persuasive. And when it comes to the leveraging a cross-examination wisely, as some lawyers try to pulverize every defense witness on a cross, but smart trial lawyers pick their battles. If a witness didn't hurt you much, maybe just ask a couple of questions just to get a useful admission, and then sit down. And don't give just a minor witness more spotlight than necessary. So save your energy and the juror's attention for the big fish, like catching the boss in a lie or forcing the HR manager to admit a policy wasn't followed. And those gotcha moments, if authentic, will be what jurors talk about in the jury like room. And however, don't cross just for show. And jurors can tell when a lawyer is badgering a witness without a real point, and it looks like a bullying and can breed sympathy for other side. And you should always have a goal for each cross and a fact to reinforce your case or weaknesses in there to expose. And the jury instructions and legal jargon, so always should be kept aside. Like work on getting favorable jury instructions with your lawyer or by yourself if you're a pro se, and often so like. The exact wording of instructions like preponderance is explained, or how retaliation is defined, so can influence the deliberations, especially in front of the jurors. And the plaintiff's attorney often fight for an instruction that if the jury finds the stacked reason for a firing was a pretext false, they may or must infer retaliation discrimination. And such instructions can give jurors to the logical conclusion. So you're just basically trying to teach them. You're not like forcing them to learn stuff. No, you're presenting it in an applicable manner. So like in a very digested form, so that it's easier for them to swallow. And additionally, so like you should always consider giving the jurors a mini lesson in a plain language, like during closing or any trivial legal concept. Like, for example, the judge instructed you on preponderance of the evidence, and that basically means whichever side is even a bit more believable wins. So picture the scales of justice like tipping slightly in Alice's favor. And it's not beyond reasonable doubt like criminal cases. It's just 50% plus a fizzer. So like analogs like that can help ensure that the jurors apply the right standard and aren't just making it harder on yours than the law requires. And and one thing is about emotional resilience. This one is more personal but crucial. And trial is an emotional, just a roller coaster, and especially when it's your case on the line. And there will be moments of frustration, and we can say something false, the judge sustains objection to evidence, and you desperately want it in. Or the defense attorney insinuates terrible things about you. And winning just means keeping your cool under fire, as the jurors do pick up on emotional cues. And if they see you openly scrolling or crying uncomfortably, so unless it's an just appropriately emotional moment, they might get uneasy. And composure suggests that the confidence in the truth. So find ways to manage stress, deep breaths, have a notebook to jot those, and and thoughts. So instead of just reacting, and whatever works. And if you need a moment, so ask for a brief recess. So your attorney can do this, or you can just request it for yourself if you're pressed. And feeling just overwhelmed can backfire. So like it's better to take 5 minutes to collect yourself than to break down in front of a jury in the wrong time. And and again, so trial is a last bastion of a fire. So like it's a war. So ideally, you should settle your case before a trial. So like no one is advising you to go to trial. It's a terrible thing. Like it's emotionally draining, and ideally just to get the settlement before it. Your case value is just rising up like the closer to the trial, and especially during the trial, so you're just at the peak value of your case. Like this may just sound counterintuitive in a video just about the trials, but one strategy to win is just knowing when not to go to trial. Even if a settlement value may not just be the amount that you're estimating, that you are just desiring just for getting this go away, but many employment cases settle. So like often because of the very just odds we discussed, like you have only 5% that 5% chance that you may win a trial, and 95% against you, even if you have a very strong case. And if you receive a settlement offer that gives you what you need, so it might be worth taking rather than just risking a zero trial. And of course, if the offer is too low and you have a principal at stake, trial might be a right call. But one secret, employers know the stats too. They know plaintiffs win rarely in these cases. So they might lowball offer thinking you will be just too scared to go to trial. And by preparing as if you're absolutely willing to go all the way, you increase your leverage. And some plaintiffs' attorneys send a message. We are ready for a trial. Our evidence is strong, and we know how to present it, which sometimes prompts a better offer on the courthouse steps. And in your context, so assuming you are going to a trial, your preparation and willingness can lead to a win, even before a verdict, via a favorable settlement at the last minute. So in a roundabout way, like everything we've discussed, not only helps you win in front of a jury, but also strengthen your case in the settlement talks. And in the very conclusion, like stacking the deck in your favor is a thing that you are just aiming for. Like to sum up, like winning a federal trial, especially in employment discrimination or harassment case, is no easy feat. Like the system prevents hurdles and presents them at every stage, like strict procedures, skeptical judges, fierce defense lawyers, and the challenge of persuading a unanimous jury. And many plaintiffs with valid grievances walks away empty-handed due to these challenges. But as we've shown, knowledge is power. And by understanding the trial process deeply and deploying smart strategies, now you can greatly improve your odds of success. And it means working harder and smarter than the odds side, like out preparing them and telling a more compelling story and avoiding the pitfalls that trap the unwary. It means transforming your case from just a complaint on a paper to a vivid narrative that motivates a jury to stand up for injustice. And remember the Alice story. It's really the story of countless employees who seek fairness. If you find yourself in her shoes, like take heart. Yes, so the road is long and the arena is daunting, but the perseverance and the tactics we discussed, from mastering the rules to captivating the jury, you can tell those scales of justice. Even David with the right strategy can beat Goliath in the courtroom, and basically so like that's pretty much it. So like there is no more secrets, and at the end I'm only can mention that it's very important for me that you are watching it and learning about the insider look at trials. So especially if you find this video helpful, like please give a thumbs up and subscribe to our channel for more deep dives into legal empowerment. And if you got questions or a topic you would like us to cover next, drop a comment. I would love to hear your ideas for the next video and to continue just helping you navigate the legal system. And remember, so knowledge, preparation, and a courage that's the triers that can win the cases. And until the next time, I wish you to stay strong, stay informed. So like, subscribe, and leave a comment with what you see, what you would like to see in the next episode. And I will see you next video. Bye.